Noted. Next point.
The point is that the words used in the if Constitution is giving power to the to make any law, it specifically used certain words in the Constitution. If my Lord kindly sees 154(5), Article 154(5). Next page. My Lord, until Majlis Shura Parliament makes provision by law in this behalf, the Council may make its rules of procedure. These are the words. Then Article 6.3, my Lord, if my Lord kindly sees Article 6.3. Article
6.3 or 63?
6.3. Article 6, subclause 3. I see him. Yeah. 6. Article 6. Majlis shall by law. Article 6, my Lord. Yeah.
जी पढ़ लिया
जी Majlis shall by law provide punishment of persons found guilty of high treason. Then my Lord will kindly see 151(2), freedom of trade. And my Lord also reads 150, subject to clause 2, trade, commerce, intercourse throughout Pakistan shall be. Majlis Shura may by law impose such restrictions. May by law. Again, sir. Then my Lord,
what is the point you're making?
I'm making.
You're just citing different provisions.
My Lord, if the word in the 191 was the Parliament can make law, these kind of expressions as provided in the Constitution would have been used, my Lord. My humble submission is that when the Constitution is giving the legislature a power to enact a law, then specifically words are used in the part.
Mr. Zubairi, there's another question.
My Lord.
Once the rule-making power has been exercised,
my Lord,
by the Supreme Court in terms of the Constitution, because the power vests in the Supreme Court, can subsequent legislation displace, as this Act purports to do so, can subsequent legislation displace the rules that have lawfully been and constitutionally been framed by the Supreme Court?
No, my Lord, that's my humble submission. They cannot, for the simple reason, because then it will become ad nauseum. For example, can now the Supreme Court, which can make law regulating its practice procedure, make a law overriding the Parliament's making of the law? Then the Parliament will do it, then where will we stop? So my humble submission is that could not have been the intention of the framers of the Constitution, that to give power to Parliament, because there are separation of power doctrines there. Once the Honorable Supreme Court has made the rules regarding regulating the practice procedure, the Parliament does not. But that practice and procedure, the rules, cannot be in violation of any constitutional provision, any law which existed, sir.
The core question is, where does the Constitution confer, in which institution confer the power to make rules?
Ji.
Whether it is the Parliament or is it the Supreme Court?
Ji.
If it is the Supreme Court, the only restriction is that the Supreme Court can do so within the framework of the Constitution and the existing law.
My Lord.
And that's it.
Yes,
the Parliament cannot, because the power does not vest in the Constitution in the Parliament in terms of Article 199.
191, my Lord.
Next point.
My humble submission on this score is that that's the reason I was saying.
I would really want to hear you, Mr. Zubairi.
Sir, my Lord is asking a question.
नहीं वो आप बात तो करें फिर सवाल उठेगा यकीनन.
पूछ रहे हैं इसी बात से सवाल उठा है सर. जी.
Now, if I may ask you, these words subject to the Constitution, if these words were not there at all, and the Supreme Court were to make rules, and someone were to point out, well, sir, this proposed rule X is contrary to the Constitution, the answer would presumably be, the Supreme Court would say, well, okay, yes, you are right, so we can't make rule X, right? So in that sense, saying subject to the Constitution is always redundant.
Yes.
Because it's always going to be there.
There.
seems to me, but this is the question, that perhaps there is a more subtle point here. The Constitution, of course, can also be amended. Yes?
Yes,
under article. But by and large, the Constitution is regarded at any given time to be fixed. Right? This is it. Underneath it, whatever happens by the judiciary, by the executive, by the legislature. So maybe the point in saying subject to the Constitution is not to make the obvious point that everything is always subject to the Constitution. Everyone knows that. But rather to fix the position of law. That when the rules are being made, what you just said, when the rules are being made by saying subject to the Constitution and the law can only be as at that
time, sir, when the rules are framed.
This is the point that is being made here, because otherwise I was thinking about this, and I've been thinking about this since the case started. Why say subject to the Constitution? Because everything is always subject to the Constitution.
Mr. Zubairi, I just want to say one thing. The day we hear this case, the weeks we hear this case, our institution exceeds our disposal. The day we don't, our disposal exceeds our execution. If you think this is a never-ending hearing, this is the last day of the hearing.
My Lord.
Please remember that. You can argue till 11:30, and each one of us may have their views. Let them be expressed in judgments. I want to hear counsel.
Sir, when a question,
I mean, if you,
my Lord,
please continue. We will restrain ourselves. You just continue your argument so we can be enlightened what you want to tell us, and we can record it, and we can either agree with you or disagree with you in our judgments.
Sir, my Lord,
आप आगे बढ़िए, please. Next point. Please go on to the next. Please go on to the next point.
So my point is that, again, my Lord, that when the law is being given to the Parliament, the hence subject to law, and for that I want to take you, my Lord, I have placed certain case law before Lordship, if my Lord has that.
दे दिए या देंगे?
ये रखे हुए सर.
पहले से नहीं दिए?
सर दिए हैं, बहुत पहले से दिए हुए रखे हुए हैं.
आज?
नहीं सर, मतलब उन्होंने कहा जब आप आर्ग्यू करेंगे उस वक्त दीजिएगा, मैं तो कब हर रोज लेके आ रहा हूँ सर.
Sorry, this is most unfair. हमने कहा था लोगों को फाइल कर दें.
ये केस हम
हाँ ठीक है, you are right, we are wrong.
नहीं सर,
we have told everybody to file. हाँ भी कागज के टुकड़े आ रहे हैं बीच में से, और ये कोई आसान चीज है पढ़ना?
इस लॉ है सर, इसमें
इन दुनिया में ऐसे होता है या सिर्फ निजाम अदल पाकिस्तान में ऐसा चलेगा? आगे दुनिया की हम तारीख में बताते हैं ये. जरा प्लीज ठहर जाइए ना कि अमेरिका में क्या होता है, विलायत में होता है. आप ये करें अमेरिका विलायत में जाकर के, फिर क्या होगा आपके साथ? वहां तो आप सारे वेस्टर्न ट्रेडिशंस बताते हैं, इस्लामिक ट्रेडिशंस तो बताते नहीं है. अगर कागज के मामले में ठीक है भाई, मेरी मर्जी जब मैं करूं. सच अ सीनियर काउंसिल.
माय लॉर्ड, मे आई टेक पेज 144 ऑफ दिस इज अ केस.
क्या आप हमें प्रोपोजिशन बताएं? पहले प्रोपोजिशन बताया जाता है.
How a subject to law has to be interpreted. That is my.
ठीक है, बता दें केस का नंबर.
Its case is page 144 of this booklet, sir.
जी.
Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word. What is the meaning of? And their constitution also provided this thing.
Their constitution also permits filing of documents in courts. चलिए खैर, 144.
Sir, this is just a case law which I'm citing.
ये सुप्रीम कोर्ट का
नहीं sir, it is Supreme Court of New Jersey, sir.
अच्छा ठीक है.
जी. My Lord, page 145. If my Lord kindly sees the sixth line from the top.
देखिए वो जरा मुनासिब नहीं लगता है. सुप्रीम कोर्ट ऑफ पाकिस्तान फुल बेंच में, सुप्रीम कोर्ट ऑफ न्यू जर्सी का जरा ठहर तो जाइए ना. हमें हमारा लेवल इतना लो तो ना कर दें. सुप्रीम कोर्ट ऑफ अमेरिका तो बताइए, आप सुप्रीम कोर्ट ऑफ न्यू जर्सी को हम फॉलो करेंगे.
सर मैं सिर्फ बता रहा हूँ कि
हाँ बता दें, जबानी बता दें. आपकी बात में ज्यादा वजन है बल्कि सुप्रीम कोर्ट ऑफ न्यू जर्सी में.
उनके कॉन्स्टिट्यूशन में इस तरह का लफ्ज नहीं है, लेकिन उनके जो स्टेट्स हैं उनके कॉन्स्टिट्यूशन में इस तरह के लफ्ज हैं. काइंडली सी द सुप्रीम कोर्ट शैल मेक रूल्स गवर्निंग द एडमिनिस्ट्रेशन ऑल कोर्ट्स स्टेट एंड सब्जेक्ट टू लॉ द प्रैक्टिस.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के हवाले से इस वक्त समाज जारी है. ब्रेक लेते हैं, ब्रेक के बाद आपको दोबारा ज्वाइन करेंगे. साथ रहिए.